judge issued his sentence, he made the point of saying that he was the youngest and was the least culpable involved in the crime, and that but that he had no choice, that unfortunately he was not able to use any discretion in sentencing, and that he wanted to have that on record, because if there was the opportunity down the line for commutation or any type of change in sentencing, he wanted to make sure that it was on record that that was how he felt, where he was basically saying, I wouldn't have sentenced you to this, but I don't have a choice.
The question that often comes up is, what is the appropriate way to treat juveniles? My name is Bradley Bridge. I'm an attorney from the Defender Association of Philadelphia. I've been attorney here for 25 plus years. I don't think life without parole is a suitable punishment for juveniles for a number of reasons. I think it's kind of a one-size-fits-all phenomena, and that doesn't work for shoes, it doesn't work for pants, it shouldn't work for human beings. So I think that what you need to do is examine the character of the juvenile involved, the type of crime involved, and figure out what would make sense, not today, but 20 or 30 years down the road.
My name is Anita Colon, and I am the sister of a juvenile lifer, Robert Holbrook. He was very, happy-go-lucky, normal teenage boy, smart, but also curious. An older drug dealer actually convinced him to come along on what he thought was going to be a simple drug deal, and offered him $500. Turned out to be a robbery of another drug dealer who was incarcerated, and tragically that drug dealer's wife was killed during the incident. My brother had no knowledge that this was going to happen, and no direct participation, but again, to consent to a drug deal is to consent to a felony, and therefore he was considered as guilty as the person that actually killed her.
You're talking about juveniles who commit a particularly serious crime, and the question is, how can we best treat those juveniles? I think probably the answer is that in some circumstances they should be treated as adults, and in some circumstances they should be treated as juveniles. And really what you need is to have flexibility to deal with that. You need flexibility also in that they should be an opportunity sometime down the road for a juvenile who has changed and is no longer the sort of person who committed a murder and doesn't have that same character anymore, for that to be reflected in their sentence. And if a juvenile is sentenced to a life without parole, there's no opportunity to ever change that sentence, which means if the person changes a lot, and we know that juveniles do change more than adults because they're younger.
In terms of juveniles not being sentenced to life without any possibility of parole, the main reason why they shouldn't be is because they're children. It's been proven academically, clinically, that adolescents' brains are not fully developed, that they're not mature and able to make clear decisions the way adults can. So how then do you hold them responsible and accountable for crimes in the same way that you would as an adult?
Laurence Steinberg, PhD, Professor of Psychology at Temple University. Lots of people ask at what age the brain is fully developed. And this is a very hard question to answer because different parts of the brain mature along different timetables. But if we're talking about regions of the brain that are involved in, let's say, the coordination of emotion and cognition, or more advanced cognitive abilities, like anticipating the future consequences of a decision that you make today, or impulse control, that those parts of the brain are not mature until early adulthood. And there's some research that indicate that they may not even be mature until the mid to late 20s. If we know that there are certain characteristics of adolescence that make them different from adults in ways that affect their responsibility for their behavior, that their immaturity ought to be taken into account when we make dispositional and sentencing decisions.
You turn around and say that a 12, a 13, a 14, a 16-year-old makes a mistake and they therefore should be suddenly, now when they made that mistake, that they should be as accountable as an adult, that they should have, been able to make that clear decision, when at the same time you're saying you don't trust them to drive, you don't trust them to drink or smoke or do any of these things. But if they commit a crime, then they should be punished the same way that an adult is. And it clearly makes no sense.
If a juvenile is charged with murder, that case automatically starts in adult court. For, 50, 60, 70 plus years, maybe even more than that, maybe back to like the 1930s, juveniles have always started in adult court. In fact, I think it probably goes back to the 18th century. There have been a number of suggestions over the years that be changed. To my knowledge, it has not yet been changed, nor has it gotten much traction in being changed. I think there is currently a feeling that that's an inappropriate way to treat all juveniles, to automatically start out in adult court. But I don't know whether any of those particular actions will lead to any fruition. Pennsylvania has probably about 450, when last I looked, juveniles serving life without parole, which puts us far and away the #1 state in the country of juveniles serving life without parole sentences. And there's probably a couple reasons that that's true. First, Pennsylvania has all juveniles charged with a murder automatically start out in adult court. So it doesn't matter how old the kid is. Kid's 10, kid's 11, automatically starts out in adult court. A number of states do not have such a provision. For very young children, those kids are automatically kept in juvenile court, or the cases start out in juvenile court and there might be discretion to send the case to adult court, but not in Pennsylvania. So Pennsylvania automatically starts out all homicide cases in adult court. The second reason that there's so many juvenile lifers in Pennsylvania more than any other state is that there are only 2 penalties available for a juvenile found guilty of murder in the first, second, or third degree. The penalty for first or second degree murder, there is only one penalty, and that's life imprisonment without parole. Only if the person is found guilty of third degree murder is there a sentence that would be a term of years. So the problem ultimately is that if a juvenile is found guilty of first or second degree murder, because juveniles cannot be executed, they can only get a sentence of life without parole.
So when we consider the appropriateness of life without the possibility of parole for juveniles, I think it's important to look at the logic of the Supreme Court's decision in the juvenile death penalty case, in Roper versus Simmons, which was decided in 2005. And in that case, the majority opinion for the court made the argument that the death penalty is the worst possible punishment that we should reserve for the worst possible offenders. And because juveniles are more impulsive and less planful and more susceptible to peer pressure than adults, we should see them as less responsible for their behavior. And if they're less responsible for their behavior, then we should not expose them to the worst of the worst punishments. And I think now it's appropriate to ask whether the logic that was used in deciding that case can also be applied to parsing the appropriateness of the life without parole sentence for juveniles.
And the funny, ironic thing, of course, is that juveniles, because they start out at a younger age, would serve more time than an adult who also sentenced to life without parole for exactly the same crime. So the juvenile who's less culpable let's say is 15 years old and lives to be the age of 70, would spend 60 years in prison, whereas an adult who, let's say, is 25 when they commit exactly the same crime and also lives to 75 would only spend 50 years in prison. So the juvenile would spend 60, the adult would spend 50, and yet we'd all agree that a juvenile of a 15-year-old or a 14-year-old does not have the same judgment or ability to reflect on their actions as an adult, and consequently the same consequences should not follow. Ultimately, if there's going to be any change in the law regarding juvenile life without parole, it's only going to be because people have explained and demonstrated that that's what their beliefs are. I think that the right answer in such a circumstance to lead to that change is for people to write letters to their legislatures, to write op-ed pieces in the newspapers, to participate in education sessions, to try to learn as much as they can about these issues, and to express loud and often the point of view that a juvenile life without parole is not a sentence that society should have.
What's most important for everybody to do is to share the information. Tell your friends about this. You know, if this issue concerns you, tell your parents and tell them, you know, this is something you care about. Ask them to contact their legislators. Contact, you know, your legislators. So you go online, and if you don't know who your state rep or your senator is, doesn't matter. You just stick your address in and it'll tell you, or your zip code, and pulls it up. And most legislators have right on their sites where you can send an email directly, you know, send letters. College students can make such an impact too, because like I said, you know, they go home and educate their families, you know, educate their friends and educate their teachers, you know, and so that's really what I think everyone can do.